All right. So we are starting today's class, but to remind you of what we have been doing in our previous discussion, we look at the concept of crime and then criminal law, of which we focused on the introductory aspects of criminal law, definition, and then the elements of a crime or offense. We said that according to Section 1 of the Criminal Offences Act, offense and crime could be used interchangeably. So we try to assess. And then we said that some of the authorities that we'll be using under the criminal law is the 1992 Constitution of the Republic of Ghana. Again, the Criminal Offences Act 1960, and then Criminal Procedure Act 30, and then Criminal Offences Act 29. These are some of the authorities. We also make good use of decided cases. So we discussed the introductory aspect of criminal law. We said that criminal law is a public law. We dealt with that extensively. And then we were trying to say that criminal law actually is not a law, but it becomes a law because the society says it should be. And then we supported that session with the fact that as and when societies recognizes and then considers a particular act or behavior and sees it to infringe upon the peace or the peaceful coexistence of the members of the society or the community, then they make sure to bring it to notice so that they will be captured in a statute for it to be prohibited. So it means that criminal law becomes a law when the society feels that it's supposed to become a law, or is supposed to be criminalized, or an act is supposed to be criminalized. We analyze the definition of a Blackstone, the definition of Professor Kenny, Glanville Williams, or Semensa Bunsu. And then from there, we also criticize them and we supported them also with cases. From there, we look at the elements of a crime. When you talk about the definition of a crime, what are some of the things that must be present before they will be considered? Again, we look at crime and civil wrong. Then the functions of a criminal law. Criminal law prohibits criminal conduct, protect the weak and vulnerable in society, protects public morality, protects public peace and tranquility, and others. So we discuss all of them. We look at the retribution and the restitution theory. We look at that and then we dealt with it extensively. So we said that when we also look at the classification of offenses, we analyze Article 19, Clause 5, Article 19, Clause 11, Article 19, Clause 21, the case of Hassan versus the state, where we realize that before an act will constitute a crime, it must be defined in a statute subject to Article 19, Clause 5. And then we also analyze Tetutu Kata versus the Attorney General, or is it the Republic? Yeah, Tetutu Kata versus the Republic. So Tetutu Kata versus the Republic, where we realize that Article 19, Clause 11 departs from Article 11, the sources of law. To be precise, Article 11, Clause 2 and Clause 3. And then we also look at NPP versus Attorney General, where we said that Ghana is not a country on its own. It is a member of a lot of international bodies, and thereby it has to also obey international rules and laws. However, they do not just become laws that we have to obey unless they are being transcribed, adopted, and accepted into our municipal laws. If not, they are by no means going to be laws in Ghana. So we analyzed that. And then I think that was where we ended everything. Today might be the last introductory lesson that we are holding. And then from there, we mean big men business. So today we are going to start from where we ended the last time, where we started analyzing the case of Parker versus Brown. Parker versus Brown, of which we said that Parker, who is the appellant, was having a license to operate a restaurant, of which some of the terms of the agreement under the license read that for you shall not accept anyone. You should not permit a person of notorious bad character to assemble and meet together at your premise. And then some prostitutes were being found at the premise of the appellant, Parker. And then by the virtue of that, he was being charged, or he was being convicted for committing an offense. So the argument rose up that when he said notorious character, what does it mean? To what extent does someone become a notorious? What is the status quo for the measurement of a notorious person? Again, if you talk about prostitution, why should prostitution become a notorious character? Because some of the Western nations might accept prostitution, while some of the Asian nations or the Arabian nations might even consider it to be a first-degree felony. So what therefore is a notorious bad character, or why is a prostitution an offense? So that brought forth the concept of morality and then criminal law. When you talk about morality, does it have any relation with criminal law? Should the criminal law enforce morals? That was where the question started from. So we ended our previous lesson on the case of Parker versus Brown. And that is where we are starting from today. So today we are looking at law and morality, principle of legality, burden of proof in criminal matters, and then the rule against double jeopardy. The reason being that these are some of the principles that must be applied before arriving or concluding on a person's conviction. So it is very prudent and so skeptical so sensible that we get to know all this. Now we are starting with the law and morality. When we talk about morality, the term morality, it can be used to refer to some codes of conduct that is actually being put forward by a society. Code of conduct that is put forward by a society. So every society has its own principles and rules. When you go to some societies, you can't greet an adult whilst you are standing. When you go to some societies, you can't greet an adult whilst you are wearing a cap. But other societies do accept them. Some societies, if your clothes is not reaching your feet, your dressing will never be considered as someone who has been raised with a high dint of morality. So we are saying that morality can be used to refer to some course of conduct that is put forward by a society. It could also be a religion. And then it is mostly accepted by an individual for his or her own behavior. So when you talk about morality, that is how we could see it. Now the question is, morality. Morality, what the society is holding fast to, morality, what the society considers so much, that morality, can the law enforce them? The answer is no, because morality is composed of normative rules. Normative rules in the context that they tell us or they set out what we should do or what we should not be doing. They just tell us what we should do or what we should not be doing. So their normative rules, their emphasis is on should, because the individual is not compelled to abide by them. We are not compelled to go by them. We are not compelled. I can decide to go by them or not. You can just call me immoral person, but I don't care. I will not be sentenced. I will not be fined. Yes. So you can call me immoral. I don't care. So we are saying that morality is composed of normative rules. Normative rules. And normative rules also set out what a person should do or what he or she should refrain from doing. The emphasis is on should, because the individual is not compelled to abide by these rules. Examples of these moral principles or normative rules are honor thy father and thy mother. Do not bear false witness. It means be truthful. Rescue a drowning child. All these are moral principles or normative principles. If you don't do them, no one can put you into prison. No one can charge you. No one can force you to act. They are moral principles. However, law, in contrast to moral as normative, law is positive rules. They are positive rules because they impose legal obligation to do or to refrain from something. They are positive rules because they have legal implications on commission or omission. So if a positive rule is being breached, punishment shall be meted. So law is made up of positive rules. Positive rules impose a legal obligation to do or to refrain from doing something. And then if a positive rule is being breached, sanction may be imposed. We have some of the positive rules or the laws to be: do not kill. Do not kill will give us murder. And murder is an offense punishable by death, though it is rebuttable because it has been amended. So murder is an offense punishable by death. Do not park on double yellow lines, contrary to local bylaws. So if there is a local bylaws that you are not supposed to park here, and then you park, before you realize, you see them towing your car. Do not steal, subject to section 24 of the Criminal Offences Act. Stealing is the taking of something that do not belong to you and appropriating it. You take it, then you also appropriate it. So he says that do not steal. Do not steal. That one also is a positive act. According to section 124, stealing is a second-degree felony. Section 124, subsection 1, down to subsection 5. Whoever steals shall be guilty of a second-degree felony. Remember, I have taught you classification of offenses. Second-degree felony, for how many years? Don't forget. Second-degree felony. First-degree felony, how many years? Up to how many years? First-degree felony, up to life imprisonment. Second-degree, mostly up to 25 years as the maximum. Remember, if my memory could set me right, that is how they are. Now, subject to section 124, whoever steals shall be guilty of a second-degree felony, where the court which finds a person guilty of the offense of stealing is satisfied that on not less than 2 previous occasions he was found guilty of the offense of stealing, the court shall order that the whole or any part of any term of imprisonment imposed by it shall be spent in productive hard labor. If court finds that a person is convicted of stealing, and then after serving the punishment, the person was also convicted for another stealing, and then the person is also convicted for another stealing, it does not necessarily mean that it's supposed to be 3 times or 4 times. If the court becomes convinced that a person is fond of stealing, that person shall be sentenced into imprisonment and then shall be imposed by it, or shall be subject to a productive hard labor. What therefore is the stealing? Subject to section 125, definition of stealing. A person steals if he dishonestly appropriates a thing of which he is not the owner. A person steals if he dishonestly appropriates a thing. So stealing does not mean that I enter into your room and then take your phone or take your money. If you send me to court, I can tell that, that money, your son was sick, so I had to use it to buy something for your son. Or that money that I took, please, I read section 124. That one talks about stealing, the scope of stealing. And then section 125 defines stealing. I have reiterated it. Section 124 talks about the scope of stealing. That is what I read. Subsection 3, a person in respect of whom the court makes an order under subsection 2 shall be disqualified for election to the district assembly within the meaning of the Local Government Act 1993, Act 462, for a period not exceeding 5 years. Someone who has been stealing. The law says that that person has to be excluded from taking part in the district assembly election. Yes, because you are not a good person in the society. Subsection 4 of section 124. For the purpose of this section, productive hard labor means labor in any state farm or state factory or any other public, cooperative, or collective enterprise specified by the minister. Subsection 5, relating to section 124, the scope of stealing, says that the previous occasions referred to in subsection 2 may include occasions which occurred prior to the commencement of this code. So it means that you are stealing that you are convicted of must happen after this Criminal Offences Act has been passed. So section 125 talks about the definition of stealing. The stealing, you know, is not stealing. If I pick your money and then you see me and you report me to police, I can never be convicted of stealing. I can never be convicted of stealing. Stealing is not picking someone's money or taking someone's phone. It is dishonestly appropriation or dishonest appropriation of something that doesn't belong to you. Section 126 talks about consent by wife in case of stealing. So that is how it is. So the next one, there is an overlap between legal and moral rules. In as much as we are trying to draw a line between morality and law, we must never forget that sometimes there are overlap between legal and moral rules. The reason be that many immoral acts are criminal because they are a threat to the well-being of the society itself. Immorality like murder, stealing, rape, etc. are also crimes. They are also crimes. Crimes such as murder, stealing are placed in the realm of primary law. So we must say that sometimes the morality and then the law overlaps each other. But my question is, if we try to say that, oh, okay, morality is supposed to be infiltrated or supposed to be incorporated into law, then the question will be, whose morality? Whose morality? Whose morality should we incorporate into the law? Is it the morality of the Northerners? I'm talking about the case of Ghana. Is it the morality of the Voltarians or the morality of the Bonos or the Ashantis or the morality of the Fantes or the accounts in general, which one should we incorporate into the law? If you are talking about morality, whose morality? It is this primary law that tempts us to argue that law and morality are the same. Please, I'm coming, okay? Let me take a sip of water. Sorry. So, like what we're saying, we are saying that sometimes law overlaps with morality. But the question is, if sometimes there are some fusions of law and morality, then whose morality should we adopt? Whose morality should we adopt? By the way, it is the primary law that tempts us to argue that law and morality are the same. The primary law of murder, stealing, and rape, which are also immoral, and at the same time they have been adopted as illegal or a crime or an offense. It is by the virtue of this that sometimes we think that law and morality are the same. In fact, criminal law does not seek to punish immoral conduct such as adultery. If we are supposed to conclude that morality and a crime or criminal issues are the same, just because murder is immoral and then it is in the law, rape is immoral and then it is also in the law, stealing is immoral and it is also in the law. Therefore, if we are trying to conclude that, oh, okay, then there is a collaboration between the law and the morality, then the next question is, what about adultery? Does the law also considers adultery to be a crime? The answer is no. However, it is an immoral act. What about a gossip? Gossip is an immoral act. However, it is not something that the law infringes upon, that it should become a crime or an offense. So we can't just sit down and say that, oh, okay, this one is supposed to become this one is supposed to become this. Not all moral principles or moral rules qualify to become a crime. Not all moral principles or moral rules qualify to be a crime. We must not forget this. Let me invite you to read with me an interesting case. Very, very interesting case, of which Mrs. is going to read it for us. A very, 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 very interesting case. In fact, I love this case. The case of Glah and another versus the Republic. The Glah case. Most often in criminal law case, you might see only one person. If it is Apia, you see Apia case. If it is Tachujikata, you say Tachujikata case. The reason being that the other party is automatically the Republic. It's automatically the Republic. So let me respectfully invite you to read with me the case of Glah and another versus the Republic, 1992 case, 2 Ghana Law Report, page 15 to page 18. Mrs., you are reading with us. The case is projected.
Okay. Gla and another versus the Republic. Gla, living in a village near Pando, had an affair with both his mother-in-law and his sister-in-law. He had 2 children each with his wife, mother-in-law, and sister-in-law.
The case is interesting. One man is married to a wife, and then behind the wife, the sister, he has chopped. In front of the sister, in front of the wife, the sister, he has chopped. The mother who gave birth to these children, he has chopped. One man, then not only chopping alone, not only having an affair with them, he has also given birth to them. Let's continue reading the fact of the case.
Okay, so excuse me. He had 2 children each with his wife, mother-in-law, and sister-in-law, and he had been living with the 3 women peacefully for 17 years.
Hey, married to the mother, married to the sisters, and then all these 3, the mother, the 2 daughters, with the man all together, staying together in the same house. They sleep in the same room 17 years peacefully. No quarrel between the mother and the children. No quarrel between the 2 children. In fact, they understand themselves. 17 years, this case, it happened in a village near Pando. Very interesting case. Ghanaian case. Let's move on.
The chief and the elders of the village and others had warned Gla and his in-laws to desist from their immoral act and association, but they paid no heed to the warnings, and members of the family of the women were incensed and ready to pounce on them. But for the fact that they exercised restraint, Gla and his 2 in-laws were charged with conduct conducive to a breach of peace contrary to Section 207, and they were convicted in the district court. They were convicted in the district court.
All right. If you look at the fact of this case, I am tempted to ask. The 3 of them were living peacefully. Why should you bring an action against them? According to Section 207, of which they were charged, Criminal Offences Act, let me read to your hearing. Any person who in any public place, I repeat, any person who in any public place or at any public meeting uses threatening, abusive or insulting words or behavior with intent, mensura, with intent to provoke a breach of the peace, or whereby a breach of the peace is likely to be occasioned, shall be guilty of a misdemeanor. Now the question is, any person who in any public place, are they in a public place? The answer is yes, they are living in a town. At any public meeting, that one also is correct. Uses threatening. The question is, was he threatening? In law, the most interesting aspect is that if all the elements are present, but one element is not present, it shall never constitute an offense. You can't say that, all of them were there, but this one wasn't there. Uses threatening or abusive, or insulting words. They are living peacefully. You are worried about them. And you are just saying that the chief is just saying that it is immoral. The chief and the others are saying that it is immoral. So the people who are actually fighting with him are supposed to be the ones to be convicted. Are the ones who are supposed to be convicted, because you are the one who are fighting with them, and then you are trying to fight against their peaceful coexistence. Let us continue with the fact of the case. Mrs., you are continuing.
Okay, so the CA
Court of Appeal.
The Court of Appeal held an appeal that the Court of Appeal held an appeal that there is no doubt that customary law frowns upon such a conduct, but it is not caught by any section of Act 29.
Sure. Remember, what does Article 19, Clause 5 say? Nothing shall constitute an offense until it is being defined, written down, with punitive measures being attached to it. Article 19:11 also talks about that. Article 19:5 says that as at the time does not constitute an offense. Let me respectfully read Article 19. Article 19, Clause 5 to your hearing, and then Article 19, Clause 11 to your hearing. Article 19, Clause 5, a person shall not be charged with, you can't finish with a criminal law without getting familiar with this article. Almost every lesson we have, we quote it. It will also help you in constitutional law and then Ghana legal system. It reads, a person, Article 19, Clause 5, a person shall not be charged with or held to be guilty of a criminal offense, which is found on an act or omission that did not, at the time it took place, constitute an offense. 11 says that no person shall be convicted of a criminal offense unless offense is defined and the penalty for it is prescribed in a written law. So the Court of Appeal held on appeal that there is no doubt that customary law frowns or speaks against it or frowns upon such conduct. But we must say it explicitly and expressly that it is not caught, it is not captured by any section of Act 29. Mrs. Continue.
Okay. So the Court of Appeal held on appeal that there is no doubt that Oh God, help me. There is no doubt that customary law frowns upon such a conduct, but it is not caught by any section of Article 29. It's not caught by any section of Act 29.
Criminal Offences Act. Move on.
Act. And the family cannot
1950 Act 29. Move on.
and the family cannot the family cannot leaven.
No, it is a type of mistake. Cannot take.
Okay. The family cannot take an easy line of things by pursuing their criminal action. The first appellant has lived with and cohabited with these spouses peacefully for over 17 years and has 2 children with each of them. If the opposition from the family is now feared, then it is the family who should be restrained.
So it is the family who are trying to impose their nose into the affairs of GLA, who are supposed to be restrained so that they don't bring fight. It is not GLA who is supposed to be restrained. Move on.
The prosecution would not take the easy course of preventing an association which is not caught by Section 207 of Act 29, simply because
remember the argument. Section 207, any person who is in any public place or at any public meeting uses threatening, abusive, or insulting words or behavior with intent to provoke a breach of the peace, or whereby a breach of the peace is likely to be occasioned, shall be guilty of a misdemeanor. So the act of GLA does not violate Article Section 207 of Act 29. Move on. The
prosecution would not take the easy course of preventing an association which is not caught by Section 207 of Act 29, simply because the prosecution feared opposition from the family.
So, just because, so you can mute it now. So just because, thank you for reading it for us. So just because the society or the family are trying to pose their nose into the personal affairs or the private affairs of GLA, does not mean that we should charge GLA for committing an offense. It is not captured anywhere in the Criminal Offences Act. Therefore, you can by no means punish GLA for it to be possible. So if you have anything to do, restrain the families who are trying to pose their nose into the personal affairs of GLA so that they will not do that. That's the case of GLA versus the Republic. Very interesting case. So from this case, we got to know that morality departs from a crime. If you look at it carefully, you could see it. That morality departs from a crime. So I must say that morality is not necessarily having a relationship with a crime. You shouldn't forget that. However, sometimes crimes could be classified based on morality. Crimes could be classified based on their conceptual immorality or inherent evil. Crimes could be sometimes classified based on their conceptual immorality or inherent evil. So a crime may be malum in se or malum prohibitum. The plural is mala in se. And then the plural for this one is mala prohibita. So a crime may be malum in se and then malum prohibitum. If you look at it carefully, malum, it means that it is bad in se in itself. In se in itself. In se in itself. It is bad in itself. Malum. In se. Malum prohibita. It is bad because there is a law that prohibits it. If there is no any law that prohibits it, it would have been good. But it is bad because there is law that is prohibiting it. So let us look at them. Malum in se is a crime. As a crime is one that is wrong or evil in itself. It refers to conduct that is thought to be inherently wrong by nature, independent of laws governing that conduct. No matter the laws that are governing it, it is wrong. A wrong like murder, even if there is no law governing it, it is still wrong. A conduct like rape, even if there is no law governing it, it is still wrong. So we shouldn't forget this. And then we are saying that conduct that is considered universally to be wrong, and then regardless of whether a law exists concerning it or regardless where it occurs, conduct that is considered universally to be wrong, regardless of whether a law exists concerning it and regardless of where it exists. So you get something like murder is universally considered to be wrong, even in the absence of laws of that effect. We also have what is called malum prohibitum. Malum prohibitum. It is a crime that is wrong because it is prohibited. Driving on the left-hand side, obeying the traffic. It is a crime because there's a law that says it's supposed to be a crime. Malum, it is bad because something is prohibiting it. Sorry. So malum prohibitum or prohibutor. The conduct is bad because the law says it's supposed to be bad. So it means that without such prohibition, it will not be considered a crime. It will not be considered a crime. So malum prohibitum, crime may not on its face appear to be morally reprehensible. Yes, morally reprehensible or morally requisite. Morally requisite or morally disregarded or bad in the absence of a law prohibiting that conduct. So had it not been a law that has been passed, it would have been acceptable. But because there is a law that has been passed, that anyone who is found committing this will not be tolerated That is why it is considered as. So we are looking at principle of legality, principle of legality, principle of legality. The power of the state to punish is not limitless. The state has a limit. The reason why the state has a limit is the reason for we saying that all conduct must be defined, and then with their punishment being attached to it. So the state cannot just punish any act, any act. No. That act must be defined, and then they can't just put any punishment on anyone. The punishment also must be defined in the statute, as we have been repeating and repeating and repeating. You must never forget this. The punishment must also be indicated in a statute. Criminal law is based on legality. It means that it must be written to afford the people in the state. So the principle of legality is captured in a Latin maxim, Nollum crimen nulla poena sine lege. Nollum crimen nulla poena sine lege. It means that no crime is committed and no punishment can be imposed without the act having been prohibited and the punishment having been prescribed by a law enacted before the act was committed. So this one is in consonance with Article 19 clause 5 and then Article 19 clause 11. So it is in consonance with that. It does not deviate. So nollum crimen nulla poena sine lege. If we try to divide them into two, we will get nollum crimen. Nothing is a crime unless it is penned down. Nothing is a crime. Nulla poena, punishment, poena, punishment, crimen. I'm giving you the secret. Crimen, crime. Nothing is a crime. If you look at it, you see that crimen and the poena are the difference. The poena is the punishment, the crimen is the crime. So let us take them one after the other. Nollum crimen sine previa lege. An act or omission to act is only a crime if before the act or omission was committed, there was a law declaring the act or omission in question as a punishable offense. This is in consonance with Article 19 clause 5. The question is, do you remember Article 19 clause 5? You must be tired of this article because you have been hearing it over and over and over. Article 19 clause 5 says that the person shall not be charged with or held to be guilty of a criminal offense which is founded on an act or which is founded on an act that did not at the time it took place constitute an offense. You have been hearing it over and over and over. It could also be supported with the case of Hassan versus the Republic. Hassan versus the Republic. The nollum crimen sine previa lege principle was well honored in Hassan, where the appellant was found in the possession of Indian hemp. Remember that case? And was convicted by the circuit court on a charge of possessing Indian hemp, contrary to the Pharmacy and Drugs Act 1961 Act 64. The particulars of the offense read, Fatai Hassan, on the 20th day of January 1961, in Accra, in the Eastern region. By then, Accra was part of Eastern region, remember. in Accra, the Eastern region, was in possession of 800 grams of Indian hemp. However, Act 64, which is Pharmacy and Drugs Act, came into force on 13th June, underline, 13th June, it came into force on 13th June 1961, in allowing the appeal against the conviction of the accused. The Supreme Court observed that on 20th January 1961, the date captured on the charge sheet, there was no offense like possession of Indian hemp, because by then they had not yet enacted or passed the Pharmacy and Drugs Act 1961, Act 64. So the principle of nullium crimen sine previa lege, nothing, an act or omission to act, is only a crime if before the act or omission was committed, there was a law declaring the act or omission in question as a punishable offense. So the principle in Hassan versus the Republic could be used to support the Article 19, Clause 5, the nullium crimen sine previa lege, and then you explain it accordingly. What about the case of Tetutu Kata versus the Republic? Let me use my mouth to tell you this case. Very interesting one, of course. In this case, Tetutu Kata was in charge. He was a board member of somewhere. I think Ghana Petroleum or so. So let me say that he was a boss somewhere. And then he signed a contract with a company outside. And then by the time that he was signing the contract, there wasn't any law talking about willfully causing financial loss to the state. So when he was entering into the contract, there wasn't any law. Listen to me carefully. This is a rebut. This is a case that could be used to contrast the case of Hassan versus the Republic. Very crucial law. In law, when you're solving law problem questions, such cases that contrast are sometimes the preference of the examiners. When you state this one, then you set to another case that will contrast it. Hi, you will kill the examiner. You let the examiner clap his or her hands for you. So, Tetutu Kata versus the Republic could be used to contrast the Hassan versus the state. When Tetutu Kata was signing the contract, there wasn't any law like willfully causing financial loss to the state. However, when Tetutu Kata was in progress of the contract, he was into it. When he was signing, there wasn't any law. So he signed, and then the contract was going on. So after some years, possibly that was when the other party had finished performing their part of the obligation. So Tetutu Kata is supposed to perform his part of the obligation, which is to provide the consideration. But as at the time Tetutu Kata was providing the consideration, there was a law. So in between the time he was signing the contract and then the time he's paying the money, there has been a law. When he was signing the contract, there wasn't any law. It's a very interesting case. When he was signing the contract, there wasn't any law, so he's safe. However, when he was paying the consideration of the contract, when he was now paying the money, there was a law talking about willfully causing financial loss to the state. So the question arose in Tetutu Kata versus the Republic, where Tetutu Kata signed a contract of guarantee in 1991. A law on willfully causing financial loss to the state came into force in 1993. Tetutu Kata signed the contract of guarantee in 1991. And the law on willfully causing financial loss to the state also came into force in 1993. And then Tertius Carter made the payment in 1996. So when you look at the fact of the case, it becomes interesting. So which one should we use for the judgment? So if the signing of the agreement in 1991 is a criminal act, then a case of retroactive use of legislation arises. It violates Article 19(5). If we are trying to use the signing of the contract, which is 1991, then the law is becoming retroactive. 2, if the payment in 1996 constituted the offense charge, there will be no question of retroactivity. Is it logical or practical to separate the execution of the guarantee agreement and the payment made in satisfaction of the guarantee obligation? This became a very tough question for the Supreme Court. Tertius Carter was contending that when he started it, there wasn't any law. Then the Supreme Court judges were also saying that, but when you were paying it, there was a law. But Tertius Carter is saying that, but when I began it, there wasn't any law. Then they took the way saying that, but when you were paying it, there was a law. So when I was starting it, there wasn't law. But when you were paying it, there was a law. When I was starting it, there wasn't any law. When you were paying it, but there was a law. So that was the argument, secular argument at court. So the third question came in, whether we can separate, whether we can substantiate the contract, the practical, like the execution of the guarantee agreement, the agreement itself, whether we can separate it from the payment made in satisfaction of the guarantee obligations. So when that argument pop up, that enlightened the learned judges, they realized that fine, we can separate the contract from the consideration. When you were signing the contract, you were free to go. After signing the contract, and then the law has come into force, you are not supposed to pay the money. You shouldn't have paid it. So the fact that you continue, as the Holy Scripture and the Bible says that the hand of Zerubbabel has started this building, and the same hand shall complete it in the Holy Book of Bible. So he who has begun the good work shall certainly bring it to an expected end. Tertius Carter, because you have started a bad work and you completed with it without giving reference to the statute that has been passed, then he will charge you on one count. The count is that for entering into that contract, you are free. But for the payment of that money is willfully causing financial loss to the state. So we have looked at the nullum crimen sine previa lege. We have looked at the nullum crimen sine previa lege, an act or omission. Whether I pronounce it well or not, you can pronounce it for yourself. An act or omission to act is only a crime. It's only a crime if before the act or omission was committed, there was a law declaring the act or omission in question as a punishable offense. Now let us look at the nulla poena sine previa lege. An act or commission to act is only a crime if a specific penalty has been previously prescribed for that act or omission. Specific penalty, poena sine previa lege, poena has been previously prescribed for that act or omission. So in Ghana, this principle is carried on two legs. The offense must be written in a law and defined, and a penalty must be prescribed for the offense. That is Article 19, Clause 11. Are you familiar with this article? Are you familiar? Article 5 says that the act will not be a crime as at the time it was committed does not constitute an offense. 11 says that must be written down, must be defined with penalty in a written law. Don't forget. If you forget anything in the Constitution, don't forget this. We have used them over and over. No person shall be convicted of a criminal offense unless the offense is defined, and the penalty for it is prescribed in a written law. Effect of the principle of legality. Effect of the principles of legality. They are there to ensure certainty in legislation. They are also there to prevent retroactivity. Retroactivity. The law is progressive. Please don't forget this. It is not retroactive or retrospective or backdated. The law is not retroactive. So that is how it is. It also prevents secret legislation. Let us quickly look at the principle espoused in the case of Deborah versus the Republic. Manasseh will read it from our platform for us. So Manasseh, visit our platform and then read Deborah versus the Republic for us. Deborah versus the Republic. Deborah versus the Republic. And then Wemega, you'll be reading Asamoah versus the Republic from the same platform. Asamoah versus the Republic. Wemega will be reading Deborah versus the Republic, 1991, 2 Ghana Law Reports, page 517. I hope Manasseh is there.
I'm here.
Oh, okay. Deborah versus the Republic. Have you seen it?
No.
It is on our WhatsApp platform.
I'm checking through, but I've not seen it.
I think that is the first one. I think that one is the first one. Deborah versus the Republic.
The first one you sent to this one.
Anyone who has today, I sent it this on, yeah. Anyone who has found it can read it for us.
Okay, Deborah versus the Republic.
Okay.
Manas, you have not seen it?
Yeah, I found it.
Okay,
okay,
go
so
ahead.
you can read for us. Okay. And then Wemega, you'll be reading Asamoah versus the Republic, 1973, 1 Ghana Law Reports, page 186. Wemega, let's go.
Okay, then let me open it. Asamoah versus the Republic.
Hey, Manasi rather, sorry, Manasi.
Oh, okay. The appellant was charged with the offense of disrespect to a chief, contrary to Section 53A of the Chieftaincy Act 1971, Act 370. The High Court held that the prosecution failed to prove that the appellant's conduct was disrespectful to the chief. The court also held that the evidence shown that the appellant's conduct was contrary to Kajibi's customs, which forbade inhabitants of Kajibi area from picking stones in front of the chief palace without permission. The court further held that the offense of disrespect to the chief is meant to protect chiefs only, and that was no evidence that the appellant's conduct constituted an offense against the chief. The court therefore quashed the conviction and set aside the sentence.
Okay. A case is better understood when it is read twice. I will do the analysis and then you read it for the last time, since I might not be able to project it here.
That's fine. I'm taking it again.
So I will do the analysis and then you read it for the last time.
Okay, sure.
When you look at Deborah versus the Republic, very interesting case. Deborah was picking stones from the chief's palace, in front of the chief's palace. And then, in fact, it is a very lengthy case, but this is the fact of the case. And then Deborah was being caught and called to the palace. When he was being called to the palace, instead of talking to the Ochami, he was talking directly to the Nana, the chief. So they said, Deborah, you don't respect. Deborah, you don't respect at all. So they were doing him up and down, trying to stress him up, and he said, me, I won't come to the palace again. Why should I be coming there for you to bully me? I won't come there again. So the chief calls, sometimes the chief will, like, they keep on calling him so that he will come to the palace, and he said, no, I won't come. So for the purpose of disrespecting the chief, you know our people, if you don't take care, they can arrest you for anything. Anything. Oh. That is why you're supposed to become a lawyer. I don't want to mention their names, but you know them. They can arrest you for anything, so far as they are in the community and you are in the society. At least if you have something small. So, so Deborah was being captured. And then was being sent to the police. So upon the trial, he was being convicted for disrespecting the chief according to the customary law, for committing a crime. Fine. Deborah appealed. And when he appealed, the appeal court upheld the case that Deborah is not supposed to be convicted for committing a crime, because rules pertaining to disrespecting a chief only protects the chief. It only protects the chief. So as a lawyer, this one speaks to you. In our villages, where the chief says that on Tuesday we don't go here, on Wednesday we don't go here, on Friday we don't do the work here, it is not applicable in criminal law. So it is not a crime. They cannot arrest you. They cannot arrest you if you do the work. If you go there and do your work. Remember, that is why when we're starting criminal law, I told you that once you become a lawyer, if your client is being charged for committing a crime, the first thing you do is ask them, where can I find it in the Criminal Offences Act? Where can I find it? Where? Show me, show me, show me. If you can't show me, then sue my client in different name, something else, not a crime. Remember that criminal issues are very dangerous. When you are even filling a form, sometimes they ask you whether you have been convicted of a crime before or not. So you can't just call someone criminal, just like that. No. So let us read the fact of the case again, Manasseh, for the last time, and then we move on.
Okay. So, Deborah versus the Republic. The appellant was charged with the offense of disrespect to the chief, contrary to Section 53A of Chieftaincy Act, 1971, Act 370. The High Court held that the prosecution failed to prove that the appellant's conduct was disrespectful to the chief. The court also held that the evidence shown that the appellant's conduct was contrary to Kajebi's custom, which forbids inhabitants of Kajebi area from picking stones in front of the chief palace without permission. The court further held that the offense of disrespect to the chief is meant to protect the chiefs only, and that there was no evidence that the appellant's conduct constituted an offense against the chief. The court therefore squashed the conviction and set aside the sentence.
That is a very fantastic case. And the reader is also good on that. And then you have done justice. Wemega, the case of Asamoah versus the Republic, 1973, One Ghana Law Report, page 186.
Section. So, in the case of Asamoah versus the Republic, 1973, One Ghana Law Report 186. The applicant was charged with selling a cake of new sunlight soup for 15. I'll use the 15p as Ghana pesos, if I'm permitted to. The applicant was charged with selling a cake of new sunlight soap for Ghana cedis 15 pesos instead of controlled price of Ghana cedis 10 pesos, contrary to section 2 of the Price Control Amendment Decree 1972 NRCD 17. The High Court convicted the applicant and sentenced her to a fine of 80 pesos of 3 months, to a fine of 80 Ghana cedis or 3 months imprisonment with hard labor. The appellant appealed against her conviction and sentenced on the grounds that she was charged under a repealed law and the sentence was excessive. The court held that the charge was not defective and that the sentence was not excessive.
All right. So there was a price controlling enactment controlling the prices of a particular commodity that you're not supposed to sell it at this amount. And then the appellant violated the principle and thereby was being convicted. The argument of the appellant was that the law that they used to convict her, that law is already repealed. Remember, I was learning it and I saw it somewhere. Where did I even write it? I think I was learning administrative law. I just discovered this, so I have to share with you. You might need it. Sometimes these things are hard to find. Let me check whether I can get it for you so that you put it at the back of your mind. Or it wasn't administrative law. Okay, if I find it, I'll make sure to let you know. We say that acts and constitution, one is repealed and one is revoked. We repeal one and then we revoke one. So when you hear, anytime you hear repealed, it stands for, when I get it, I will let you know. Anyway, we can continue. So this case is used to support the argument. It is used to support the argument that the principle of legality, the situation whereby one, the case of which the party is being convicted of, that case, as at the time it was, that case, I repeat myself, the principle of legality, number one, the case of which the victim, or let me say the defendant to be convicted of, that case must be defined in a statute. Number two, that case or that statute, that law must be in force. It must not be an authority, a statute that has been repealed. No, it must be a statute or authority that is in force. So technical errors and then subject matter, they are very important. They are very, very important. So the principle of legality when it comes to a case, as a lawyer, you should look at the legality of the issue. Is that issue written down? Does it have penalty being attached to it? As at the time my client was committing it, was that statute in force, or it was being repealed, or it was being revoked? As a lawyer, you must know this one before you even follow the case. If not, you go and defend and defend and defend and defend. Later on, realize that your client is actually being charged of a law that is being repealed. Any act that you pick, the preliminary, the beginning, like the preface of the act will tell you, any act you pick, it will tell you the number of acts it has repealed, number one, or consolidated. So it either repeals it, it takes it out, or it consolidates. It consolidates, it adds it to it. So when you pick any act, check. When you check it, you will see it. I don't know whether I can get some of the acts and read it to your hearing. And read it, especially this act, Act 1036. What is the Land Law Act? Act 1036. I don't know whether I can find it so that I could read it to your hearing. Let me look at it. Act 10. That is what even came in their exams. The Makola exams, please take it serious. That is what came, the Makola exams, the entrance this year. Some of the amendments that the Act 1036, Land Law Act, has done. Let me read it. Republic of Ghana, the 1036th Act of the Parliament of the Republic of Ghana, entitled Land Act 2020. An act is to revise, number one, harmonize, two, and consolidate the laws on land to ensure sustainable land administrative and management, effective and efficient land tenure, and to provide for related matters. So if you look at it carefully, it talks about the law, what the act is actually doing. And then I've actually forgotten the specific place, which is repealing several acts. I'll put it on the platform for you. It is repealing several acts, and then it is also consolidating several acts, such as the Conveyancing Act, all of them. It is bringing all of them into one umbrella called the Land Act. So the principle of legality, you go to the law and try to find out whether what they are using to charge your client, the principle of legality stands. Very, very important. So that is how it is. Let's move forward. So in all criminal cases, the burden of proof is beyond reasonable doubt. Please, criminal matters, the burden of proof is beyond reasonable doubt. You can't just say someone has committed a crime just like that. Sure. Charlie, crime, it must be beyond reasonable doubt. According to Section 11 and Section 13 of the Evidence Act 1975. Mrs. Can you read it from the platform for us? Section 11 and Section 13, subsection 1 of the Evidence Act 1975. It is on the platform. Read it to our hearing. The principle of legality. So we are here, the burden of proof. The burden of proof. The onus. O-N-U-S. O-N-U-S. The burden of proof lies on the prosecutor. The one who is saying that someone has committed a crime. The burden of proof lies on that person. That person has to prove beyond reasonable doubt. You can't just say that someone has committed a crime and then you just use your mouth to say it. Proof beyond. So you say criminal matters are proved beyond reasonable doubt. Very important. Message, we can read it to our hearing.
Hello. Okay, so Section 11 of the Evidence Act 1975, NRCD 323. It defines the burden of producing evidence as the obligation of a party to adduce sufficient evidence to justify a finding on the issue in dispute. Section 13(1) of the same Act provides that in criminal proceedings, the burden of proving the guilt of the accused person lies on the prosecution and that the accused person is presumed innocent until the contrary is proved.
The accused person is proved or is considered innocent until the prosecutor proves beyond reasonable doubt that it is not like that. Manasseh will read the case of Otin versus the state on the platform. 1966, Ghana Law Report 355. Otin versus the state. Otin versus the state. Otin versus the state. Otin versus the state. Otin versus the state.
Okay. So in the case of Otin versus the state, 1996, GLR 352, the appellant was convicted by the district court in Sawem on 2 counts, namely careless driving contrary to section 18(1) of the Road Traffic Ordinance, and 2, negligently causing harm contrary to section 7(2) of the Criminal Code 1960. He appealed from his conviction to the High Court, Accra, but his appeal was dismissed. He thereupon appealed to the Supreme Court on 5 grounds, the substance of all of which, taken together, is that the prosecution failed to prove any carelessness or negligence on the part of the appellant, and consequently, the trial district court magistrate misdirected himself in holding that the accident was caused by the appellant swaying his car to the left in the course of overtaking a scooter rider by the victim of the accident. The Supreme Court upheld the conviction of the appellant on both counts.
If you look at this case, you could see that the convicted or the appellant tried as hard as he could to escape the judgment. However, he was still held convicted. The basis of his argument was that the prosecuting or the prosecutors or the prosecuting team failed to prove beyond reasonable doubt that he so acted negligently. He failed to prove beyond reasonable doubt that he acted negligently. However, the court held that the case against him must suffice. So, though we are saying that you have to prove beyond reasonable doubt, the prosecuting team, it is, however, not every doubt in the case for the prosecution which should lead to the acquittal of an accused person. So it does not necessarily mean that you have to prove. If there are some evidence, what else do you want? You have committed offense. That's all. Also in Miller versus Minister of Pensions, 1947, 2ALLER 375 at 373, it was stated by Denning. Don't forget this judge. If you forget any judge, don't forget two, Lord Parker and Lord Denning. Very famous judge, Lord Denning. Lord Denning. Lord Denning. Never forget Lord Denning. Lord Parker, who gave a lot of judgments in UK. And then Lord Denning, very intelligent, seriously intelligent judge. So he held that the law, or he dissented that the law will fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. Look at the case of Deborah. If we are juxtaposing it, if you are trying to juxtapose it with the case of Deborah versus the Republic, you could see that the community tried to punish Deborah, and then he was being convicted just because he disrespected the chief. Lord Denning is saying it in the case of Miller versus Minister of Pensions that the law will fail to protect the community if it admitted fanciful possibility to deflect the course of justice. If you're a community and then you issue useless laws, and then you think because you are a chief or you are a king, your subjects are supposed to, by all means, bow down to it and follow. The law will never entertain it. The law will fail to protect the community if it admitted a fanciful possibility to deflect. That means to divert the course of justice. We are not going to take it into consideration. We are not going to mind you. Wherever you like, take it to. So we are still on the principles of legality. We have looked at the burden of proof, where we have seen that the burden of proof lies on the prosecutor. And then criminal matters are also tried in public. Or let me say, are tried in open. So criminal matters, we don't put it somewhere. We tried it in open. It is only in the Bible that Jesus Christ was being tried privately, instead of doing it during the day so that everyone will see. They did it at the dawn so that no one will see. By the time the day breaks off, they have already sentenced him to death. And then everyone will be asking, what happened? What happened? Then they will say that he said he's the king, which is a treason. So we have sentenced him to death. So all criminal matters are supposed to be tried in open. You have to look at the principle of legality. Every issue must be codified, identified with penal consequences or penalties in a written law. Very, very important. The burden of proof, the onus, O-N-U-S, onus. Onus lies on the prosecutor. The burden of proof lies on the prosecutor. He has to prove beyond reasonable doubts. Beyond reasonable doubts. However, in the case of Oten versus the state, we have seen that the prosecuting team, the fact that they are supposed to prove it beyond a reasonable doubt, does not mean that if they are having a necessary or a sufficient evidence, they are not going to be allowed. You can't just come and say that, oh, they couldn't prove beyond reasonable doubt. They couldn't prove beyond reasonable doubt. So if there are some evidences, what else are you expecting? Evidence are beyond the reasonable doubt. So it is very important. Then we look at the rule against double jeopardy. That is our next thing, and then we end with it within the next 10 minutes. Within the next 10 minutes, maximum. Maximum. The rule against double jeopardy. The rule says that no one should be punished twice for the same offense. Someone committed stealing, and then he has been punished twice, probably by High Court and again by Supreme Court or by Appeal Court. That is wrong. Or you have tried the person. You try the person. Trial means, I hope you know the trial. You have tried the person. Like, you have listened to the cases, you have cross-examined, you have tried the person. And upon the person's acquittal, you have called the person to try the person against. It is against the rule of double jeopardy. The rule against double jeopardy, it is double jeopardy. So we are saying that no man should be punished twice for the same offense. Once a person has been tried for an offense, he cannot and he can never be tried again for the same offense. Whether the person's offense, or let me say, whether the person's action led him to his acquittal or conviction, whether the person was acquitted or was convicted, the person is not supposed to be tried twice. No man should be punished twice. You shouldn't punish man twice for the same offense. Again, once a person has been tried for an offense, that person is not supposed to be tried again for the same offense. Whether his trial ended in acquittal or a conviction. Whether the person was being convicted or was being acquitted, you are not supposed to try the person twice. So that's the principle of double jeopardy, against double jeopardy. You should be able to say it well. No one is supposed to be punished twice. No one is, and no person has to be tried for an offense. He can never be tried again for the same offense, whether his trial ended in acquittal or a conviction. No one is supposed to be tried twice, whether the trial ended in acquittal or conviction, and no one is supposed to be punished twice for the same offense. This led to the principle of autrefois convict and autrefois acquit. Autrefois convict, and autre fois acquit. What is the ideal or the rationale behind the double jeopardy? Why are we not supposed to punish one person twice? Or tried the same person twice? The reason being that criminal law seeks to prosecute offenders, but not to persecute them. Hey, I'm telling you this. The essay part, criminal law seeks to prosecute offenders, not to persecute them. Discuss. So if you want to discuss, you have to start with double jeopardy, the rule against double jeopardy. Then you'll be supporting it with cases. So criminal law seeks to prosecute offenders, not to persecute. Prosecute, not persecute. They persecuted Jesus in the Bible. By criminal law, we prosecute. That is why we have prosecutor, but we don't have persecutor. In the criminal law, we have prosecutor, special prosecutor, but we don't have persecutor. So once a person has been tried and sentenced, he cannot be punished again for the same offense, since to do so would amount to undue oppression or persecution. If you do that, it will amount to undue oppression or persecution. You must get constitution for yourself, please. You must get constitution in a hard copy. You are all politicians. You are all politicians. Politicians must get constitution wherever they go. Politicians, you are all politicians, please. Make sure to get constitution for yourself. So let us read from Article 19, Clause 7. I hereby invite you to read with me. No person who shows that he has been tried by a competent court for a criminal offense and either convicted or acquitted shall again be tried for that offense or for any other criminal offense of which he could have been convicted at the trial for the offense, except on the order of a superior court in the course of appeal or review proceedings relating to the conviction or acquittal. It means that this is a rebuttable presumption. Look at it. I take it again. No person, it is better understood when you take it twice. No person who shows that he has been tried. So anyone who shows, who can point his hand that, oh, I have been tried. Remember, the court of first instance is high court. When you talk about court of first instance, it means that 8 mouth is open. For high court to the one same. For high court to the one same. So the mouth of high court is open. It has set any case. It is a court of high instance, both civil case and then criminal case. Both civil case and then criminal case. That is high court for you. It takes every case. It takes every case. Subject to Article 139. Charlie, you must know the law. Everything you must quote. Subject to Article 139. Clause 1. The High Court shall consist of A, the Chief Justice, B, not less than 20 justices of the High Court, and such other justice of the Superior Court of Judicature as the Chief Justice may, by writing signed by him, request to sit as High Court Justice for any period. Clause 2, the High Court shall be constituted. This is Ghana legal system, Ghana legal system, Ghana legal system. Article 137, Ghana legal system. The High Court shall be constituted by a single justice of the court or by a single justice of the court and jury. So I want a portion. Good. Article 140, clause 1. The High Court shall, subject to the provisions of this Constitution, have jurisdiction in all matters, in particular in civil and criminal matters, and such original, appellate, and other jurisdiction as may be conferred on it by this Constitution or any other law. So it means that High Court have jurisdiction in all matters, and in particular in civil and criminal matters. Article 140. So High Court, the court of first instance, back to Article 19, clause 7. No person who shows that he has been tried by a competent court for a criminal offense, by a competent court, say High Court, for a criminal offense, and either convicted or acquitted, shall again be tried for that offense or any other criminal offense of which he would have been convicted at the trial for the offense, except, underline it, except on the order of superior court. So except the case is being appealed to appeal court or being sent to Supreme Court, except that, notwithstanding clause 7, clause 8 reads, notwithstanding clause 7 of this article, an acquitter of a person on a trial for high treason or treason shall not be a bar to the institution of proceedings for any other offense against that person. Mrs. Mrs., let me hear from you. You were saying something. I saw it late.
Oh, okay. I wanted to know the article. Is it article what?
I've quoted several articles, so which one?
Yeah, you said the High Court.
High Court is Article 139, talks about High Court. And then Article 140 continues. Article 139 talks about how High Court will be constituted or instituted. How High Court will be instituted. How High Court judges are being appointed. The qualification. All of them falls under Ghana legal system. And then Article 40 talks about the jurisdictions of the High Court. The jurisdictions of the High Court. Article 142 talks about regional tribunals. Regional tribunals. Regional tribunals. Article 136 talks about the Court of Appeal. The Court of Appeal. The Court of Appeal. And then Article 126 talks about the Supreme Court. The Supreme Court. All these are Ghana legal system. You should be mindful of them. To better understand them, turn to chapter 11 of the 1992 Constitution, starting from Article 125. Article 125 to better understand them. So that is the rule against double jeopardy. You can also see Act 30, the Criminal Proceedings Act, Section 113 to Section 117. That one also talks about the accused must show that the first trial ended in a final verdict of guilty or not guilty. So before you can bring an action in double jeopardy that I have been tried and you are trying me again, you must be able to show that the case ended in a final verdict. The case ended in a final verdict. It is not about the noli prosequi or noli prosequi, as others will say. When you talk about noli prosequi, we are talking about a common law approach that is normally used to squash a case. So if a prosecutor is following a case and then he has followed it to an extent that he is no longer getting an evidence, or he's tired of following the case, he will pick what is called noli prosequi or noli prosequi, and then he will file that form and then send it to the judges, telling them that he's tired of following the case because probably one or two reasons. Probably he's not getting any evidence, or probably the evidence that he's finding is delaying more than necessary. So you find the noli prosequi or the noli prosequi, telling the judge that I no longer wish to continue the case. I've put the meaning and everything on our platform. You can read it. When the noli prosequi or the noli prosequi is being issued, remember that it does not mean that there is a final verdict. The prosecutor has decided to stop following the case. It means that in some days to come, if he gets an evidence, he can now come back and handle the case. So what we mean is that the double jeopardy principle applies when there is a final verdict resulting in acquittance or conviction, acquittal or conviction of the accused. So that's the principle of double jeopardy. That's the principle of double jeopardy. What next do we have is the end. So we have looked at all the foundations and the basis that you will use to build your problem-based question in criminal law. Whatsoever we have done so far are the ones you use to build, to spice up, let me say, to decorate your criminal law problem questions. These are the backgrounds. When you are bringing this stuff, you see that this person is learned. So we have built the foundation. Now we are coming to build on it. 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 So that is how it is. Today I have a gift for you, but I'm giving you 5 minutes break. 5 minutes break. I'm giving you 5 minutes break. However, before we leave, if you have any question, it is welcome. Your question is welcome. Your question is welcome.
I have a question.
Your question is welcome.
I have a question.
It's welcome.
Okay, so I wanted to ask,
Who is talking, please?
Yes, Manasseh.
Okay, Manasseh, respectfully, you can talk.
Yeah, insects. Is insects a criminal or a criminal act in Ghana?
Very good. When you reach second semester, you'll be doing the substantive offenses. Substantive offenses. I don't know whether I should let you have the appetite for it, Godwin, next semester. I don't know whether I should leave you for you to have the appetite for 8 Godwin next semester. You'll be doing the substantive offenses, the one that will send you to court. You'll be doing assault, you'll be doing rape, you'll be doing stealing, you'll be doing defamation, you'll be doing female genital mutilation, you'll be doing causing harm by omission, negligently causing harm, threat of death, you threaten someone, exposing child to danger, kidnapping, abduction, child stealing. You'll be doing all these stuff. Human trafficking, child abandonment. You'll be doing all those stuff second semester. Second semester. Child abandonment. You'll be doing offensive involving dishonesty. That is stealing, armed robbery, elements of stealing. So I don't want to go ahead of the time. I would rather prefer for you to be thirsty for God the next semester, whether destiny will teach us or destiny will not teach us. So you'll be doing a lot of stuff, God the next semester. That one will make you the proper lawyer. You'll be doing armed robbery or robbery, first degree felony. You'll be doing extortion, all of them, you'll be doing them. Yes, you'll be doing fraudulent breach of trust. Fraud by false pretense. Someone pretending that he is someone whilst the person is not. It's a crime. You'll be doing all of them. That is what will make you a lawyer. So we look at the difference between stealing and then false pretense. Falsification of account. Falsification of account. You'll be doing them. Dishonest receiving. You'll be doing a lot of stuff God in the next semester. We call them substantive offenses. You'll be doing forgery. You'll be doing forgery. All of them. You'll be doing them. It will make you a lawyer. Proper lawyer, of course. Unlawful entry. Unlawful entry. When you enter someone's premise. Trespass. You'll be doing trespass. Offenses involving damage to property, such as unlawful damage. You'll be doing all of them. Narcotic offenses. You'll be doing them. Narcotic offenses. Whereby you look at the locus classicus case, which is Nyameneba. So let me whet your appetite a little small. You see that you are now becoming a lawyer. You look at some special offenses and then look at the case of Malam Isa case. Malam Isa versus the Republic, 2003 to 2004 Supreme Court of Ghana Law Report. Charlie, let me leave it here. So
apparently, the reason why I was asking the case of the insect was because of the case we read about Gal. Can't hear me.
I'm listening to you.
That was not insect.
Yes,
that
but
one was not. That one was not insect.
What was it?
It was a sex. He was having an affair with the wife's, his sister-in-law and the brother-in-law.
And the mother as well.
No, not his own mother.
Oh, okay. All right.
If he was doing that with his mother and his own sister, they are fine.
I get you. I get it. All right, sure.
Okay. I think something flashed me. I don't know. Maybe I might mistake or I might be right. If I had it right, if you are charged with a criminal, if you are punished, or maybe you face criminal charges, and maybe the court gives you verdict on it. I heard something like you cannot be punished with the same offense again. I don't know if I'm wrong. You read a case and then something like that popped up.
Could you respectfully repeat yourself?
Assuming I'm charged with an offense, and then the court gives verdict on it, I'm punished in relation to the charges against me, which is a criminal offense. I cannot face same charges again.
Sure, but the same court, which is high court.
Really?
If you are being punished, you can't face the case again. Even if the same case, the prosecutor fails to get to know all the charges that they're supposed to give to you, and then reduce the charge. After charging you and you are being convicted, they can never come and add up another charge. Probably you were being charged of stealing. After you are being convicted and being punished, they now later on realize that, hey, he went there with a gun, so it is armed robbery. What is written is written, like the principle in the Bible. What is written is written. That is how it is.
I have a question on that.
Unless otherwise, we send it to the higher court of judicature. Higher court of judicature. That one, they are come to review it. They are come to go through all over. So that one, other issues might pop up. But you the same court. That is how it is. Yes. Okay, let me respectfully answer. Let me respectfully throw some light on Manasseh's question, though Wemega, you answer it appropriately, you say. So let me answer it from the legal perspective too. We have, according to section 105, you can write it down and read it yourself, Manasseh. Section 105. In fact, from section 97 going talks about sexual offense. Section 97 going is talking about sexual offense of the Criminal Offences Act, Act 29, Act 1960, whereby section 101 talks about defilement of a child under 16 years of age. For the purpose of this act, defilement is the natural or unnatural carnal knowledge of any child under 16 years of age. Defilement is the natural or unnatural carnal knowledge. We learn this one next semester, so don't worry. So the incest is 105, incest. A male of 16 years or over who has carnal knowledge or of a female whom he knows to be his granddaughter, daughter, sister, mother, or grandmother. I hope you are getting it. Commits an offense and shall be liable on summary conviction to imprisonment for a term not less than 3 years and not more than 25 years. So which type of offense is that? For a term not less than 3 years and not more than 25 years. So which type of offense is that? Classification of offenses. Which one? Hello, can you hear me?
We can hear you.
You following well?
I think that's second degree.
Second degree felony.
Second degree.
Second degree felony. Second degree felony. Second degree felony.
We also had a discussion concerning this Anas case in our previous discussion, and then I think it was the maximum was 3 years imprisonment.
No, not maximum. No, not maximum.
It was minimum instead.
No, listen to me. The maximum is 25 years, so you can. The maximum is 25. It does not mean that the person should go in 25. When it says something is maximum, it means that even 1 is part, 2 is part, 3 is part, 4 up to 25. I hope you are getting it.
Sure.
Good. So, Ohima, your line went off. Ohima, are you in?
No, she's not in yet.
I've
Her
admitted
audio
her.
is not. Yeah, she's not in.
Okay. So, Mr. Manasseh, section 105, incest. A male of 16 years or over who has carnal knowledge of a female whom he knows to be his granddaughter, number one, daughter, number two, sister, number three, mother or grandmother commits an offense. So, your wife's sister is not here. Your wife's mother is not here. I hope you are getting it.
Sure.
Yeah.
The daughter your wife came to marry you with is not here.
Oh, okay.
You are saying, oh, okay. Why? Why?
Now I'm not doing saying quiet.
But yeah, it's not why. So that is the principle of immorality and moral. If you do that, it is immoral, but the Lord does not speak against.
I did not get it.
But I got the criminal lawyer the same contract too. Or Manasseh, I like.
So,
all be interesting.
Ohima, before you left, Manasseh asked about incest. He was trying to juxtapose it with the case of Glad versus the Republic. The man who took off the wife's sister, and the wife's mother. Can you hear me?
Yes, please.
So he was asking whether it wasn't incest. So we try to use section 97 downwards. In fact, chapter 6 of the Criminal Offences Act talks about sexual offenses, whereby section 97 talks about rape, section 98 talks about definition of rape, whereby the definition of rape is the carnal knowledge of female of 16 years or above without her consent, the carnal knowledge, carnal. Section 99 talks about evidence of carnal knowledge. Section 100 talks about effect of void or voidable marriage with respect to consent. Section 101 talks about defilement of a child under 16 years of age. When you defile a child, go and touch here. Defilement. We have the indecent assault. And then we have section 104 on natural carnal knowledge. Remember, we have carnal knowledge and we have unnatural carnal knowledge. Unnatural carnal knowledge. Unnatural carnal knowledge. People who sleep with animals, they are part. Unnatural carnal. And then section 105 talks about incest. That was what message we were discussing, of which you left. I hope you could hear me.
Yeah.
Of which we said that section 105 of the Criminal Offences Act says that subsection 1, a male of 16 years, a male, not a female. Incest, a male, not a female. Good. A male of 16 years. When you're analyzing law, analyze it to a law so that you can bring arguments. So that, but they said a male, it is not a female.
I wanted to question you on this.
But the next question is, that female, if it is not a female, that male, who is he doing it with? It's definitely going to be a female. Now the next question is, if it is going to be a female, then the act says that a male of 16 years, then it means that the female will not be convicted. Charlie, when you read the law, you have to tease out. So a male of 16 years or over who has a carnal knowledge of a female whom he knows to be his granddaughter, daughter, sister, mother, or grandmother commits an offense and shall be liable on summary conviction to imprisonment for a term of not less than 3 years and not more than 25 years. And we saw that any classification of offenses, any offense that is not more than 25 years is a second-degree felony. Don't forget. And then if you look at what I've read, you could see that it confirms what you are learning because the law has been defined. The penal consequences also has been defined. Nolla crimen previa what? Ligue or sine ligue, something like that. So that is how it is. Now, Manasseh wanted to ask something that, hey, then the females. Family, my phone just hit down. It's not easy. It's not easy. Okay, Manasseh raised a question. Then subsection 2. A female of 16 years or over who has carnal knowledge of a male whom she knows to be her grandson, son, brother, father, or grandfather commits an offense and shall be liable on conviction to imprisonment for a term of not less than 3 years and not more than 25 years. Wemega, I hope your question is captured, your doubt is cleared. So that is how it is. Yeah, I think it's okay. I think you are bringing the rest of the cases, bring them to our office for money, so that we charge you money. So that that one is the lawyer's knowledge. The teaching aspect has ended. So the rest, that's all. So the man who chopped the wife's sister, and the wife's mother has not committed incest, because the wife's sister is not his sister, and the wife's mother is not his mother. So,
and it's not even a criminal offense.
It is not a criminal offense. All right. So permit me to save the recording. All right.